So Nathan, we're back for part two of our South China Sea podcast. In our last podcast, we kind of like explained the law of the land a little bit what happened with the decision of the Permanent Court of Arbitration, in particular, the core issue of what a maritime feature is and when it begins to be an island, which then will have ramifications for the country's extension of its reach into the sea.
Sure.
Today we want to talk about 3 points. Part one, about the jurisdiction of the Permanent Court of Arbitration to decide actually this dispute between the Philippines and China. We know that China did not actively participate. We'll get back to that in a second.
Yes.
We want to talk a little bit about the legal ramifications that the decision will have. And then we'll end off by having a look at what's currently happening, if you will, almost every day.
Sure.
All the potential listeners will have heard about freedom of navigation exercises that are routinely conducted in Australia.
Yes.
In fact, is now part of these freedom of navigation exercises, and we'll talk about that a little bit.
Sure.
Okay, let's start with jurisdiction. Whenever an international tribunal, court-like, quasi-court setting wants to decide a dispute, the first thing in international law that has to be clarified is, does that body have jurisdiction? And it can only ever have jurisdiction if the parties to the dispute actually gave it the power to sit over this dispute.
Yes.
Generally, that can happen by way of a treaty, to submit any disputes out of a treaty to a certain body, whether it's the International Court of Justice or some other judiciary body, or it can be by ad hoc declaration of a country that they are happy to submit to the jurisdiction of an institution. What's the jurisdictional framework for this dispute decided by the Permanent Court of Arbitration in The Hague?
So we're looking at both parties being signatories to UNCLOS, the United Nations Conventions on the Law of the Sea. So that's the first position point, is that both parties are signatories to the convention. UNCLOS contains dispute resolution procedures, compulsory procedures that are built in. Remembering also that UNCLOS...
So in other words, we have a treaty here,
we have a
and a treaty has a dispute settlement mechanism
Sure.
and provisions that speak to it.
Absolutely. So basically, we're also remembering that UNCLOS is meant to govern all the uses of the oceans and seas in the world. That's what we're looking at, because we're looking at history and the history behind UNCLOS, and we're looking at codification and basically the one-stop shop for all sea-related matters in peaceful purposes as well. So we start there with the compulsory dispute resolution mechanisms. We also look to the United Nations Charter, because we also have the peaceful purposes grounding in dispute resolution as a starting point as well. And the UN Charter is also mentioned in the preamble to UNCLOS.
Of course, but there's nothing in the UN Charter that would give anybody jurisdiction to settle this particular dispute.
Well, that might be a side issue we might have to leave the time.
Okay. Fair enough.
So we go to UNCLOS, we go to the compulsory dispute mechanism, but we also have an issue where declarations can be made by signatories that don't recognise or don't participate in these formal compulsory dispute resolution mechanisms. China had a declaration about this. So that would be a barrier to jurisdiction.
So in other words, China submitted a reservation-type declaration which cut back the potential dispute settlement reach of the provisions in UNCLOS.
Yes.
So the situation then, for a starting point, is there is dispute resolution provisions in the United Nations Convention, in that treaty. Those provisions would be sufficient to give the Permanent Court of Arbitration jurisdiction to deal with any dispute arising out of UNCLOS provisions. China has a restriction on, in other words, it cut the reach of these provisions to below 100%, which is possible.
Yes.
In multilateral treaties, in fact, it's very common that countries issue reservations to limit the scope of certain provisions that they can't deal with. So what was the position of the Philippines
Yes.
to say there is jurisdiction, and obviously of the tribunal itself, the Permanent Court of Arbitration, to say yes, there is jurisdiction, and
Sure.
what was the position of the Chinese to say, well, hold on a minute, perhaps not?
Yes, it's the principal question. So what we're looking at is the declaration that China made about the compulsory dispute mechanism in UNCLOS. Is that mechanism relates to maritime boundary delimitation. So for a question about that, China said that's not somewhere we're going to go. The other issue relates to...
So in other words, China
sovereignty.
said, look, there may be general jurisdiction for all of these matters, but we've explicitly said
Yes.
we shall not be entertaining dispute settlement procedures if the dispute is about boundaries and
Delimitation.
sovereignty. Boundaries, delimitation, and sovereignty.
Correct, yes.
And what did the Philippines say to that?
So the Philippines...
And
Yeah.
the Permanent Court, in
Sure.
essence.
So the Philippines said, well, okay, we will ask the tribunal to look at the status under UNCLOS of these maritime features. Like I said before, there are hundreds of maritime features in the South China Sea. What the Philippines did was to ask the tribunal to look at 8 of those many, 8 which are contested, of course, but it was the assessment by the tribunal of those features to determine whether they are islands, rocks, low tide elevations, or something completely different.
So in other words, the Philippines basically said, we're not concerned about boundary delimitations, we're not concerned about sovereignty. What we're concerned with is we want to know what the legal status is of this maritime feature.
Yes.
Is it merely a rock?
Yeah.
With the consequences that rocks have, which
That's
are
correct.
much more limited,
Yes.
or is it an island
Yes.
with the legal consequences that islands have,
Yes.
which are much more far-reaching?
Yes.
And therefore, that's what we're concerned about.
Yes.
Of course, the consequence of these findings
Yes.
has very much to do with maritime border delineations, right?
Well, what we would say, of course, that's a good way of putting it, but what for the Philippines was very careful to point out was that we determine the tribunal determines the classification, the status, and if the tribunal says that it's a rock, well, ownership's not really an issue, or it might not be an issue. If it's a reef or a low tide elevation, well, there can be no prescribed zone to that, so it doesn't matter. So ownership would only come into it if the classification was something recognised in UNCLOS to a prescribed zone. So we're talking about, I guess, taking the power away by classifying or having classified something which
Well, in
no one can own.
essence, is the jurisdictional
Absolutely.
question determined by a narrow understanding of the subject matter, or is the jurisdictional question also influenced by the broader consequences of that classification? If you look at just at the classification question, you could say it has nothing to do with delineation. It's
Yes.
just about whether a rock is an island or a rock.
Yes.
And that has nothing to do with delineation and sovereignty.
Yes.
If you look at the consequences,
Yes.
you could probably say. So it's interesting
Yes.
that the Permanent Court of Arbitration followed the more narrow view. What is the question?
Yes.
And the question is about the legal qualification of those formations.
Yes.
And that's it.
Yes.
Consequences at that stage do not play a role.
That's correct. And the other 2 areas that the Philippines asked was that we look at some of the activities that China's been doing in the South China Sea and of the various rights and entitlements in the South China Sea. So there are some other questions there that the tribunal looked at as well.
Okay, so let's go to the ramifications here, part 2.
Yes.
The Permanent Court of Arbitration, in essence, found in favor of the Philippines,
Yes.
and in essence said for all of those 8 features that they are rocks and not islands, and that therefore the legal consequences of that are what?
So some of the features were determined to be rocks, and some were determined to be low tide elevations. So basically, what the tribunal was saying is that the zones that China has endowed on these features can't stand in international law, have no basis. So that was the outcome, really, that these features do not have the
They don't change the
elements.
qualification
Exactly.
of the formation, right?
That's correct, yes.
What is a rock does not become something else because I attach a landing strip to it.
They're not
in essence,
transformed, that's right.
And the immediate consequence of that legally is that whereas these rocks might, if they belong to China, which is a separate question which
yes,
wasn't
right.
was not part of the proceedings, right?
No.
If they belong to China, they could have the 12-mile territorial water zone around it, but they could not have around them the 200-mile exclusive economic zone.
That's correct.
For exclusive exploitation of any and all resources in that 200-mile zone.
Yes.
That would be an immediate consequence.
Absolutely.
If they belong to, the same would be true if they belong to the Philippines.
Yes.
They would carry the 12-mile zone around it, but not the exclusive economic exploitation rights usually associated with the exclusive economic zone.
That's correct.
That would be the immediate consequence of that.
Yes.
Now, these types of decisions, in international law, we have this distinction, and it's not only, we don't only have it in international law, in trying to determine what is the legal reach of a certain decision. And if we link that to national law, if A sues B for $1,000, the decision that's rendered obviously is a decision that's relevant only for those two parties.
Yes.
We call that an inter pares effect of a decision. And then if a domestic court were to proclaim a principle of law in the context of that, obviously that principle of law would extend beyond the two parties.
Yes.
And would be a principle of law, at least henceforth, applicable to everyone, and not limited to the parties.
Yes.
How is it here for these decisions of, say, the Permanent Court of Arbitration, in essence for all international courts?
Yes. So what we would say, you're correct. The decision is binding on the parties. That's correct in the immediate case. However, the interpretation of the Rocks Islands article in UNCLOS has now been elaborated by the tribunal. So we now have, case law. We have authority. We have, a classification, a map of how to classify features in the future according to the tribunal's ruling.
So in other words, whereas this particular decision might be inter pares between the Philippines and the People's Republic of China, the fact of what is a rock and what is an island is that part has ramifications for any and all rocks in the sea.
Correct.
And is material that will have to be overcome in argument to say that the tribunal was wrong. It's not law in the sense of technical precedent, but it is a weighty piece of evidence as to what the customary international law says, or what the relevant provisions in the UNCLOS Treaty say as to what constitutes an island,
yes, that's
and
right,
what constitutes some other maritime feature that is not an island and has therefore different legal consequences.
And that's exactly what's happening. So now we have all these features around the world, in the world's oceans, that a state may have claimed was an island, but it might be a rock. And therefore, the maritime bands, the zones that can be endowed to that feature, may be significantly reduced, or might be nothing at all. So these are the wider ramifications of the tribunal decision.
So it's a really interesting decision that will have lots of effects down the line.
Absolutely, to come.
And your PhD will shed more light on that.
Finally,
because that is in the news so much, we have these freedom of navigation exercises. That's usually the terminology used in the news. And then the Americans ride some warships through the South China Sea, and even Australia is now participating, and other countries are doing that. What's all of that about?
So the freedom of navigation operations are essentially a protest, an international protest against the expansive territorial claims of China in the South China Sea. They're a public statement to say that we don't recognise those expansive claims. They're not properly founded in international law, as in UNCLOS, and we'll have a presence there and move through there to show that, to illustrate.
And the interesting thing is that under international law, a country is entitled to sail its commercial vessels, but also its military vessels through all waters. And the only restriction really is that in the 12-mile zone, after the baseline, after the internal water, so to speak, only in that 12-mile zone. They still get to sail them.
Yes.
They just have to get their weapons down, and the submarines have to be visible, so they
Yes.
can't be submerged.
Yes.
But that aside, the Chinese Navy could circumsail the Australian continent until the cows come home, and it would not pose a legal issue. So if that is so, and I'm pretty sure that is what it is, I think we agree, yes. One would think, well, what are they protesting against? Obviously, whoever wants to sail through the South China Sea, the Americans can legally sail through the South China Sea. So what are the Chinese on about there?
I mean, that's the question, is why are these protests and threats happening when another country, another state sails or flies over these areas or through these areas? Is it an issue of control? Is it an issue of threats? I mean, that's the
Could it be that the Chinese position here goes actually a step further, that they are moving towards looking at that whole area almost as if it was a lake, as an internal waters? Because internal waters is where you can keep everybody out. Nobody has a right to sail or do anything in the internal waters.
Yes.
Is that what they're looking to do?
It appears so. I mean, I'm trying to think about the source of international law that would permit them to do so, but you're right. I mean, any country can sail through a territorial sea as long as it's obviously continual transit. They're not stopping, they're not, fishing in the waters, all that sort of stuff. So it begs the question of what is the bigger picture, and it could be exactly what you've just talked about. It could be that the Chinese are treating these areas, these bands of water, as if they were internal waters, which would be a very worrying situation for the international community.
Yeah. Or maybe the benign interpretation might be that they are just protests because they are not doing this with civilian vessels, are they?
I don't believe so, no.
So merchant vessels, commercial vessels have not been affected by this.
No.
Maybe it is just a form of protest that maybe many countries would voice, say, if a carrier unit sails through your 12-mile zone. Let's say if the Chinese were now to send their aircraft carrier and 3 destroyers and sail it around off Fremantle in the 12-mile zone, maybe the Australian government would also say, is that really necessary?
Yes.
We're a bit nervous here.
Yes.
And that wouldn't necessarily mean that they say it's legally wrong that you're doing that, but they would say it's, we regard this as unfriendly,
Yes.
That you're doing this without our consent.
Sure.
And unfriendly and illegal are two separate things in international law.
Absolutely. And I guess that comes down to some of the broader issues that are happening here. The purpose of the freedom of navigation is to, as I said, to protest the expansion, the extraterritorial reach of the Chinese. It's one of those questions. Sure. Are we looking at a situation where we're simply where a state is asserting the right of passage through in international waters or through territorial sea, or are we looking at some other form of gesture? So at the moment, my research indicates at the moment that we have these phone ops are protests. Freedom of navigation operations are simply protests, and the display of the general rights of passage in maritime law. But I guess time will tell. That's the question now. As time will tell how far the Chinese will look to make these bands of water into some sort of security zone, because they have declared the defence identification zone around an area in the East China Sea. So there's a bit of speculation at the moment about what the next step will be.
So this will be an issue that will be with us for some time.
Absolutely. It's
and we know that one advantage, if you will, of Chinese politics is they are in it for the long haul, whereas Western politics is usually geared more to the short term.
Sure.
And so we will follow that closely and probably have a cause to come back to it not once, not twice, maybe several times. Thank you very much, Nathan. And until the next time.